I'm Robert George, Director of the James Madison Program in American Ideals and Institutions here at Princeton, and we're delighted to be co-sponsoring this conference in honor of Professor Whittington with the Department of Politics here at Princeton under the chairmanship of Alan Patton. Professor Whittington, who is the William Nelson Cromwell Professor of Politics here at Princeton, has served this university with enormous distinction for more than 25 years. As the tribute to Keith in your program says, he is a towering figure in constitutional studies and the study of free speech. And we've just been very blessed to have him with us for 25 years. We are, as I said last night, grudgingly handing him on to Yale Law School, but wishing him the very, very best, wishing him continued success. And now we are moving to our opening panel on Keith's work on constitutional interpretation and construction. And to moderate and introduce the panel, I'm turning things over to Professor John Breen, who's a visiting fellow of the James Madison Program and is a professor of law at Loyola University in Chicago. Professor Breen.
Thank you, Robbie. As Robbie said, yes, I'm a professor at Loyola University in Chicago. But this past year, it's been my great pleasure to be a visiting fellow here in the James Madison Program in American Institutions and Ideals, and it's just been a wonderful experience and terrific to have this conference is honoring Keith Whittington as kind of a capstone. To have this opportunity to explore some of the topics in constitutional law and theory that have been part of Keith's intellectual life, and to which he has made a significant contribution. This first panel, we have a wonderful group of scholars to explore the topic of constitutional interpretation and construction. Let me introduce them. Jack Balkin is the Knight Professor of Constitutional Law and First Amendment at Yale Law School. He's also the founding director of Yale's Information Society Project. He also directs the Abrams Institute for Freedom of Expression and the Knight Law and Media program at Yale, a member of the American Academy of Arts and Sciences and the American Law Institute. He's the author of 9 books, including Memory and Authority, The Uses of History in Constitutional Interpretation, as well as The Cycles of Constitutional Time and Living Originalism. Christopher Green is the professor of law and the Jamie L. Whitten Chair in Law and Government at the University of Mississippi. He's a graduate of Princeton University, Yale Law School. He also holds a PhD from Notre Dame. He's written extensively about constitutional theory and the 14th Amendment, including the Privileges and Immunities Clause, the Due Process Clause, the Equal Protection Clause. He's also written about the Commerce Clause and the Oath Clause in Article 6. He sees constitutional construction through the lens of stakes-sensitive epistemology. He has the distinction of being cited 3 times in Supreme Court opinions. John McGinnis is the George C. Dix Professor of Constitutional Law at Northwestern University School of Law, a graduate of Harvard College, Balliol College, Oxford, and the Harvard Law School. He clerked on the D.C. Court of Appeals and then served in the Office of Legal Counsel in both the Reagan and George H.W. Bush administrations. The author of several books as well, including Accelerating Democracy, Transforming Governance Through Technology, and Originalism and the Good Constitution, a past winner of the Paul M. Bator Award, given for an outstanding legal scholar under 40. We will go in order just as they're seated here, and we'll begin with Jack. Presentations 5 to 10 minutes, followed by a response by Keith.
So at 5 minutes, just scream at me, okay?
I'll scream. I can do that.
That's it. Hey everyone, how are you this morning? I hope you're doing well. First of all, I want to thank the James Madison Program for inviting me to come down here to welcome you to Yale Law School. That's a joke. We are here to honor the amazing achievements that Keith has had here at Princeton. And of course, once you leave Princeton, it's all downhill from there. So this is a kind of a Festschrift. I want to talk about constitutional interpretation and and Keith's contributions to it. But since I'm the first speaker, I thought I would try to tie together the early Whittington to the medium-sized Whittington and the later Whittington, so that you can see some of the connections here. And I will end with a question to Keith that he can respond to. So Keith writes 2 books at the beginning, at the end of the millennium and the beginning of the new millennium. One's called Constitutional Interpretation, which is still the best sustained book-length defense of originalism, and Constitutional Construction. By the way, no shade for you, John. No shade. And the second book is called Constitutional Construction. And in the second book, he introduces the distinction between a constitutional interpretation and constitutional construction, which turns out to be an incredibly important idea. I should just explain, for those of you who don't know, that it's very rare in an academic career that you have even one good idea, right? And Keith's had more than one. But this is really a really important idea. The distinction is roughly as follows: that courts are tasked with the job of interpretation, because Keith is a original intent originalist, a certain kind of original intent originalist. Their job is to figure out what the original intent was, and apply it. On the other hand, constitutional construction is a kind of exercise by the political branches in which they deal with things where the Constitution doesn't quite give you the answer, and they come up through accommodation, give and take, bargaining, political, pushing and pulling. They come up with solutions, and those solutions then basically become part of the apparatus of the state as the state builds out over time. So in other words, there are kinds of settlements, and there's a whole literatures on conventions and settlements, but basically, Keith is interested in not that question of settlement. He's interested in the question of how the Constitution is interpreted by the political branches to solve particular problems. And from this perspective, whereas constitutional interpretation is only supposed to be about law, constitutional construction freely mixes questions of policy, law, constitutional interpretation, expediency, political compromise, and such. And he gives wonderful examples of them throughout the book. So one of the problems of being a great thinker is that people will abuse and misuse your ideas. If you're not a great thinker, people don't abuse them because they don't even know about them. But in this case, I hear him one of the chief abusers of his ideas. I'm not the only one. But a whole group of other folks, new originalists they're called, and they decided to take this interpretation construction distinction, and they decided to use it for the development of the new originalism. And that in this version of the distinction, all branches of government, not just the political branches, but also the courts, engage in constitutional construction. Now, there are lots of different versions of this. So some of them have a relatively narrow zone for construction, which is building out doctrine. Some have a broader version, and as you can see with me, I have an extremely broad version. You might even say overweight version of the construction zone. And so you get different versions and flavors of originalism depending upon how you think about it. Now, this is not what Keith had in mind. Keith's view was that construction is done by the political branches, and the judiciary engages interpretation. So that's where it was roughly about 2002, 2003, or something like that. But of course, much has happened since then, and that's what I want to talk about. So I'm interested in Keith's current views on the question of whether courts engage in constitutional construction. I want to talk about it first in terms of his later work as a political theorist, a political scientist doing the theory of constitutional development, and also his latest work on academic freedom and freedom of speech. So one of the points that Keith makes in a very fine book in 2007, Political Foundations of Judicial Supremacy, which I recommend highly, it's just a fabulous book, is that the work of the courts is always built out through interactions with the political branches. And indeed, the political branches helped shape and construct what judges do. They create jurisdictional predicates, they create institutions, they appoint new judges, they do all sorts of things to basically construe it. And also they basically get into fights with courts, and out of these fights, various kinds of, and they push and pull, and things happen. So under this model, At the founding, judicial review was very limited. It was very limited. So I'm going to go a little longer. So there you are. Judicial review is very limited, and not what we have today. This very robust, strong form of judicial review we have today. It just didn't exist at the founding. But over time, through what I would call constitutional construction, the political branches making decisions about all sorts of things, building institutions, essentially coaxed and goaded the judiciary into what we now have, the strong judicial review. So here's an interesting way of synthesizing Keith's earlier work with his later work. Suppose that what happened was, as a sort of political settlement, the political branches created a kind of judiciary and judicial review which would engage, it would itself would be a construction, and what they constructed was a judiciary that engaged in construction. You see? So then the original model where courts are only engaged in interpretation would be changed. They would now engage in construction as well as interpretation. So that's one possibility. And it's possible that as the state expands and gets bigger and more powerful, you actually need the development of doctrines that require some degree of strong judicial review. That's an interesting question to consider. But anyway, that's one way it might have happened. The second thing that Keith, work that I want to talk about is his latest work on freedom of expression. And academic freedom. And here he's written a bunch of articles recently on controversies around regulation of teaching in universities, and he's written a book, and now there's another book coming out called You Can't Teach That, when is that going to be out?
Next week.
Next week, right. So what's interesting about these books is in these books he talks about First Amendment doctrine. And a lot of the doctrines he talks about are from the Warren Court era. So it's really hard to derive them from the original intention. I mean, we can work at it. I mean, I have ideas of how you could do it, but it's very hard to do it. So what he's doing in these books is relying on what I would call judicial constructions of the First Amendment, and good for you, too. I think that's actually a good thing to do. And he's not doing it merely as a lawyer who doesn't believe in the arguments he's making, because he's a political scientist. He's not some lawyer. He actually believes in the arguments he's making, and therefore, I think he must be now committed to the idea that judicial construction is okay in our age. Now, why it might be okay in our age has to do with the development of the state and the creation of modern educational institutions and also modern forms of government pressure on these institutions, which undermine ideas about academic freedom and free speech. So once again, it seems to me that the process of state building and the growth of the state and the dangers posed by the growth of the state create the need for judicial construction. But he has never said a word about any of this. And so today, I would like to ask him, what's your view? Thank you very much.
Mr. Green.
Oh my goodness. I can't put two books there. That's too thin. Okay. They're just props anyway. Okay. So on the whole, I am a huge fan of almost everything Keith has written about interpretation and construction. And in rereading his material, I found myself in several dozen places thinking, wow, that really is a great way to make that point. Scholarly conventions and time constraints being what they are, however, I won't spend time explaining the many things he's gotten right, but instead two things that I think he's gotten a bit wrong. So the first is his idea in constitutional interpretation. Well, all you know is that the book is gray. I don't have the book covers, but the gray book. But popular sovereignty is the best normative explanation for the bindingness of the Constitution on people today. Now, I agree that the Constitution is descriptively an act of popular sovereignty. That's how the text describes itself. We, the people, do ordain and establish this Constitution. But this is an act of popular sovereignty of the founding generation alone. Contrary to how folks like Jed Rubenfeld and Justice Breyer read the preamble, we the people is not an intergenerational, temporally extended constitutional author, but one limited in time to the founding. How do we know that? Because the preamble carefully distinguishes two recipients of the blessings of liberty: ourselves, the actual constitutional author, and, separate from that, our posterity. Later generations aren't included in the constitutional author itself. Keith argues that the ability of people today to act as popular sovereigns is what makes the Constitution binding. As an expression of the sovereign will, the Constitution is binding not because we currently accept its particular terms in their entirety, but because we accept its project, its grammar. The Founders' Constitution gains authority over us by giving us the capacity to reject it. With deliberation and care, individuals consented to become a citizenry, choosing to live under this Constitution and no other. The grandeur of American constitutionalism is that we might make the same choice again. And so because, and only because, the written Constitution provides the condition for people today to potentially exercise self-government, Keith says, it's binding today. This doesn't seem right to me. For office holders, I would point instead to the practice of taking the Article 6 oath. Contrary to Keith's claim, oath takers do indeed accept the Constitution's particular terms in their entirety. Unlike certain churches, which sometimes allow exceptions to creedal subscription, we don't allow officers today to swear to uphold only most of the Constitution. Article 6 and Article 2 oaths are all or nothing. What about non-office holding Americans? Here, the Constitution does not attempt to justify itself for later Americans on the basis of our ability today to perform similar deeds of popular sovereignty. Instead, the Constitution lists several tangible benefits it's attempting to achieve: a more perfect union, justice, tranquility, common defense, general welfare, and liberty. It does not seem reasonable to interpret the blessings of liberty as the blessings of potential future popular sovereignty. Rather, these are actual tangible benefits. If we were able to govern ourselves, but only at the expense of our unity, justice, tranquility, defense, and welfare, that sort of trade-off would not be enough to make the Constitution binding. Rather, future generations are obliged to respect the Constitution because it has actually improved our welfare relative to how we would be faring without it. We have a duty to be good stewards of these benefits. As Elon Werman puts it, following Madison's response to Jefferson, the Constitution represents a debt against the living. That debt exists because of improvements in our welfare and flourishing, not merely in providing the conditions of hypothetical self-government. Ever since the late 1500s, the Anglo-American political and legal tradition has emphasized the welfare of the people. As Cicero put it, the salus populi, as the most important political consideration, trumping even claims of self-government. But Keith's only reference to the Ciceronian tradition is to get this backward. Keith says that under the Constitution's view of popular sovereignty, the people themselves were their own judge of what constituted the salus populi. And he says the popular sovereign did not rule for the good of the people, but governed in accord with the will of the people. My representative is not an independent actor, but must be responsive to my will. This doesn't seem right. The people are properly sovereign only to the extent that they do not make self-destructive choices about their welfare. As Edmund Burke put it, a representative is required to put his constituents' interests above his own, but he may not properly sacrifice his mature judgment about those genuine interests to their misbegotten opinions. It's no different with the Constitution. Being actually good for people today is both necessary and sufficient, even if people today are too short-sighted to see it. Okay. My second issue with Keith is his claim that construction creates meaning for the Constitution. In construction, he says, the text is brought into being. Sometimes we need the construction of meaning. In construction, constitutional meaning is shaped so as to accommodate contemporary political needs and desires. Construction is a recognition of the changing nature of constitutional meaning. The meaning of the Constitution is a very real prize of political struggle. A political process gives meaning to the Constitution, the process of constitutional construction. Those are all what Keith says. Now, I appreciate Keith's careful histories of the controversies over impeachment, state and federal power, and the modern national security state. He describes powerful, long-standing political traditions forged in moments of crisis and resistant to change during ordinary politics. They are the sort of thing that Britain calls its unwritten constitution. In that sense, we have an unwritten American Constitution. But it's a mistake to describe these traditions as the Constitution or as constitutional meaning. That phrase is properly reserved for the document itself, expressing meaning in its original contexts. The text that many of us carry around in our pockets uses the phrases "this Constitution" and "the Constitution" 12 times each. The references to the Constitution all refer to times after the founding, and it's clear that the two phrases refer to the same thing. The self-referential "this Constitution" that office holders swear to obey is the same as the Constitution, that is, America's only Constitution. Keith recognizes that these textual "this Constitution" self-references require originalism. As a fixed and relatively clear text, the Constitution can refer to itself as law of the land. Only a fixed text can be adequately ratified, that is, legislated into fundamental law. The Constitution is self-referential, naming procedures for its own ratification and amendment, and naming itself as the supreme law of the land. For much more on this, by the way, see my "This Constitution" article from 15 years ago. But if this Constitution, the one that was in my pocket, is the Constitution, the only one America has, then whatever the status of long-standing political traditions like the ones they have in Britain, the sort of thing that people like Walter Bagehot call the English Constitution, it would be unhelpful to refer to these difficult-to-change American political traditions as the Constitution. They're definitely a part of how we arrange governmental power in America. And if, as a matter of jurisprudence, we want to use the term Constitution to refer to the most fundamental ways that people arrange governmental power in a country, that's okay in a political science sense. In sophisticated, scholarly parts of the university, like a politics department, it might be okay. But in a conceptual milieu where the historically situated document describes itself with an exclusive phrase like the Constitution, and we aren't positioning ourselves to reject that document, then it's misleading at best to say that this other thing, because it's an important part of how governments are arranged in America, should get the title Constitution as well. So I encourage Keith not to try that at Yale Law School. They allow it, but again, they allow it, but it's not good for them. Keith refers many times in his books and articles to the Constitution itself, 41 times by one count I made. Many of these distinguish it from constitutional constructions. But once this distinction is made, it really isn't appropriate to speak of these constructions as constitutional constructions that involve the creation of constitutional meaning. They involve the creation of very important political traditions that are very difficult to dislodge. But if we really accept the document's description of itself as the Constitution, we should honor that self-description by finding other ways to talk about political traditions that are not binding under the Article 6 and Article 2 oaths. Thank you.
Thanks so much to the James Madison Society sorry, for inviting me here today. It really is a great pleasure to speak about Keith Whittington's work. He's been one of the most important originalists of his generation. I think it's obvious that he's also the most important originalist who's not a lawyer, and I think that's been to his great advantage in some ways for pointing out the institutional and political structure within which originalism and constitutional interpretation exists. So in any questions I raise today, nothing should be suggested that I'm not a great admirer of his work. And so let me actually try, I'll depart from my written remarks to try to focus on the two issues and maybe add one other that have been raised so far. The first is the interpretation-construction distinction, which Jack illuminated and described. Now, I'm someone who has not been persuaded that the Constitution has much of a construction zone, but I think his distinction is very valuable because it forces us to consider the empirical question of how much irreducible indeterminacy there is in the Constitution. And moreover, I think Keith is exactly right about two other more controversial matters related to the distinction, which came up also, I think, at least implicitly in Jack's remarks. First, unlike most legal scholars who accept a large judicial role for construction, Keith believed construction is primarily, if not exclusively, a matter for the political branches. The judicial power is limited to saying what the law is, and it's limited to saying how the Constitution should be interpreted. Keith makes persuasive points about how the Constitution can nevertheless be construed according to its each political principles in each generation. But it's crucial for Keith that the Constitution should never enshrine these ephemeral constructions into law. But Keith is also right that one shouldn't assume that the Constitution is abstract unless language is indeterminate. He's also right that that's an empirical question. Thus, he's not guilty of the fallacy of Ronald Dworkin, who argues that language that can be abstract should be interpreted abstractly. When in fact, originalist scholars are showing empirically about so many clauses of the Constitution, from the terms due process to cruel and unusual, is what to modern ears might seem indeterminate, just reflects our ignorance of how these terms reflected the corpus juris of their time. Now, I think this puts Jack's question in some sense acutely, because what I see Jack as doing is interpreting as requiring judicial power to be interpreted abstractly to perhaps include the authority for construction. And this, I think, forces Keith to draw a line between interpretation and construction, which is a line that I find sometimes not entirely clear in his work. How ambiguous does a term have to be open to construction? One view that has some support from figures as disparate as the Democratic Republican Thomas Jefferson and the Federalist Fisher Aids is that one just takes the better view, what's called the 51-49 rule. But if that's not the rule to resolve ambiguity, it would be useful for Keith to tell us what evidentiary rule helps us to understand how to distinguish between interpretation and construction, since that does so much work in his theory. And then the next question, which I think is very important when we look at a term like judicial power, is what part of interpretation is open to Keith's insight that the question of meaning is empirical. At one point in his rich description of Chase's impeachment, Keith implies that the Federalist interpretation of the impeachment clause against the backdrop of the common law was legalistic and therefore a construction. But why isn't the degree to which the Constitution is written in the language of the law also an empirical one? Just like how abstract are its empirical terms, we could look at the document and the rules of interpretation at the time, try to figure it out. Perhaps they're unclear, but if so, we'd apply whatever rule we have to deal with unclarity to decide whether it's a matter of construction or a matter of interpretation. Of course, to be sure, the Federalists had political motives for their position, just as Democratic Republicans had for theirs, but surely it can't be that motivation distinguishes interpretation from construction. I think also one issue I share with Jack is the interesting question of where doctrine fits in the interpretation-construction distinction, because at times Keith suggested in his previous work, he puts doctrine on the interpretive side of law, and that's, I think, an interesting move. But how often do intricate doctrinal tests flow from the words or the intent that are the touchstones of interpretation? Perhaps we should therefore accept, we have choices. We accept doctrine maybe as construction, or maybe doctrine needs some reformation if it needs to be interpretation. So let me then go to the question that Chris Green raised about the normative justification grounding in originalism and popular sovereignty. I think that's a wonderful insight, that originalism is needed to protect the sovereignty of the people. That is the fundamental separation of powers, the separation of powers between the people and their rulers. But also, and I think this gets to Chris's point, it's not maybe quite enough to say that, because in some of his work, Keith also touts the good characteristics of the exercise of sovereignty. It's just not that abstractly sovereignty is good. Actually, it leads to deliberation and reflection, and we get, therefore, a good constitution of the kind that Chris discussed. But unlike his abstract argument, those depend on the historical circumstances in which popular sovereignty was exercised. We can imagine a popular sovereignty that was exercised in a slapdash way, quickly, in a narrowly majoritarian manner, or under pressure from some internal or external powers. Would that product deserve the same respect and originalist interpretation? In other words, I wonder whether Keith should distinguish between his more abstract thesis of popular sovereignty and a more particularized thesis that may depend on the historical attributes of the United States' exercise of sovereignty. How much is each doing the work of justification? So let me add one other area, and this is, I think, one of the striking things I think about Keith's work, and why one has to talk fast in talking about his work, is he's at so many of the fault lines of originalism. I haven't even mentioned that he has interesting arguments about original intent versus original meaning originalism, but of course the constitutional construction distinction, the justification of originalism, these are the fundamental issues of originalism, and he's offered new and incisive ideas about them. I think the question for the fault line of originalism now is really originalism and precedent. Because now that we have a court where many justices, maybe a majority, or at least originalists or fellow travelers of originalism, the question is, what are they going to do with it? And the greatest practical issue for that is the relation of the cases, the Supreme Court cases, which are full of precedent that, well, I think some of it at least is non-originalist, and originalism. What's the relationship between this? What is the court to do? And there seem to be three basic alternatives. First, overrule them all, or most of all of them, and destabilize the law. Second, overrule none of them, or very few of them, and make originalism a more pristine, but a rather academic theory. Third, find some principle to overrule some, but not others. But how does originalism provide that? Keith appears to suggest that almost all non-originalism precedent is open to overruling, but that the Supreme Court, and here I think he's bringing in the political science insight, can control the pace by its choice of cases, assuring stability and fidelity to originalism simultaneously. I see this move as the originalist equivalent of Alexander Bickle's The Passive Virtues. While the Supreme Court must decide cases by law when the cases come before it, it can decide what cases to take by acts of political statesmanship. One difficulty I'd like perhaps Keith to explore is that some originalists aren't comfortable, though, with the discretionary certiorari that allows the Supreme Court to make these choices, and certainly not the even more modern practice by which the court selects questions, not cases, for its decision. In any event, I'm very pleased that Keith is going to Yale and continuing to look at these questions. I would have said that it's an advantage because, of course, questions of stare decisis are very much concrete questions of law, and therefore he'll have the advantage of going to a law school where those questions are considered. I'm not quite sure if that were the comparative advantage he was seeking for his work, that he made the right choice.
Professor Whittington.
Well, thank you very much. I didn't bring props. So look, I will probably repeat this over the course of the day, but I'm immensely grateful for colleagues on this panel. It's a wonderful event in general, and it's particularly nice to bring together both a group of scholars who are friends and extraordinary scholars in their own right who I've learned a great deal from over time, and my work sort of inadequately engages with many of the same themes and difficulties that they struggle with as well. And so it's wonderful to get reactions from such a group, and it's also wonderful to get hard questions from such a group. And so I appreciate it, and I won't attempt to answer all such questions here. One feature of making this break and going to Yale at this point is that we have, I think, although not my area of interest in political science, but I think this will be a quasi-experiment where 20 years from now you can look at the quality of my work over the next 20 years and compare it to the quality of the work over the last 20, 25 years. Best I can tell, everything else will be held constant. So the only difference will be whether Yale's intellectual environment is better than Princeton's intellectual environment. And I will make no predictions as to what the quality will look like down the road, but we'll see. Let me just take up a few of the questions, though, that came up. And like I said, not so much to provide answers, but at least to note their significance. And I do think, actually, several of these are important points, some of which, of course, have been on my mind before, because they have already come up in literature and what people have said in other contexts, but many of which I have not actually gotten to and talking about yet in my own work, but might in coming years. Whether Yale Law School will be quite the place that presses me to think some more about the technical aspects of some of this remains to be seen. So let me sort of take a little bit some of these questions in order as they were raised. So perhaps in a fit of inappropriate modesty, I didn't refer much to the idea of constitutional constructions in the book about the political foundations of judicial supremacy and the development of the court over time. But I think Jack's quite right to say that that book is essentially concerned with how the court has developed and how we've reimagined the way in which judicial power operates within the constitutional system over time, in a manner that is quite consistent with the kinds of things I was doing in the constitutional construction book and looking at other kinds of historical traditions and settlements that occurred about how our constitutional institutions operate in practice. And I think he's right to suggest that one way of thinking about how the court has developed over time is that effectively the political system as a whole, including the elected democratic branches, have effectively constructed a judiciary that they expect to be much more activist in what it does and to engage in, as Jack characterized it, to engage in more construction over time. They have tried to pass off a whole set of constitutional questions that might have been resolved in the political arena through constitutional construction, but instead now many would prefer are resolved in courts, but still through a process of constitutional construction, which makes the courts, I think, a much more political institution than perhaps they should be or might have started off being, but perhaps are such now. And I think that's a fair characterization, both of what the book tried to do, and I think my assessment of sort of where the court is. One thing I decided not to try to do in the Political Foundations book which was part of my original thinking about that book, was to do more discussion of the normative issues associated with that project and whether or not that's a good project for us to have followed or whether that was a mistake to have gone down that road and what kind of normative concerns we ought to have about a court that has taken on this kind of role. But as a descriptive matter, I think that is true. The court looks much more like this. And that raises, I think, both sort of important questions about the nature of our constitutional system now and what kinds of work we should expect out of a court. It also poses interesting challenges, I think, for current justices who might be inclined to be more originalist and maybe take a different view about the nature of the judicial power more broadly, but how do you reconcile what the court has become with those sort of underlying kinds of commitments? And I have to admit that in part, in building some on what John mentioned about the role of doctrine and how it ought to fit into this kind of characterization, I have found myself over time becoming somewhat more sympathetic to the idea of more construction type activity going on in the courts in general, including through the development of doctrine and the like, trying to work through how the interpretation construction distinction I tried to develop in that early work might encompass some of that more broader range of judicial activity. I think maybe a project for the future, maybe near future. But I agree that it's a challenge, and I've become, I think, more interested in that issue and more open to that possibility that courts are engaged in a lot more construction activity, and maybe unavoidably so, than I suggested they ought to be in the early work. Jack also quite provocatively points in particular to the questions of First Amendment doctrine associated with academic freedom and how this might in any way, shape, or form be reconciled with an originalist constitution, this kind of idea of the interpretation, construction, and distinction. And the short answer is I'm not going to try to do that. And the potentially longer answer is if the court starts getting originalist about the free speech components of the First Amendment, there's going to be a lot of changes. I'm not necessarily enthusiastic about that prospect either. And if the court starts looking like it's seriously interested in that, I will have to seriously engage with a normative project about how to work that through. At the moment, my expectation is the court seems not to want to extend its originalist logic into that particular area of law. They seem content to continue to build with the very complex set of doctrines that emerged initially out of the Warren Court, but has been further complicated and extended in subsequent courts, and the court seems content to leave that as it is. And then the question is, okay, well, that's our starting point. Then what can we do with the logic of that kind of doctrine? So as long as that's the playing field that the court seems to want to operate on, I'm content in my own normative work lately focused on academic freedom to try to play with that as well. But if the court becomes more interested in trying to think through how originalism might apply in this context, well, things will get complicated in different ways. And I guess I will have to try to get complicated with it. But we'll see how that goes. So some of Chris's points, I think, are very well taken, and I don't know if I have a lot immediate to say about it, except to acknowledge that I think these points are very valuable ones. I think John pointed a bit to some of the responsive thinking about Chris, where I tried to, I think, in parts of the early work to suggest that there are that while crucial features of the popular sovereignty question of where the authority of the Constitution comes from is fundamentally one of exercises of will by the people, and that we have a commitment to respecting that kind of democratic decision-making, even when we think the people are making bad choices. But there are both normative and practical limits as to how much deference we ought to show to that. And so there is some boundary. One, there's some expectation that the choices that people make, generally speaking, are nonetheless going to be good ones. And that's part of why we value democracy from my perspective in the long term, as we think in the long term it will lead to better government, even if there might be individual choices that seem like not particularly good ones. And moreover, I think from an individual perspective, there's lots of decisions at the extreme that may well be made in which we think that the people in exercising their will make, in fact, such terrible decisions that we think this political system that they have constructed doesn't have adequate legitimacy to lead us to want to adhere to it or be obedient to it, and may even force us to think that we ought to be seeking modes of revolutionary change in order to overcome it. And so in order to command a kind of legitimacy, the people, not only do we want a system in which the people get to make decisions, but also we have to think through whether those decisions are within, I think, pretty wide margins, at least, of being normatively acceptable decisions, even if not necessarily the most preferable decisions. One feature about the American Constitution is I think we are mostly in the good situation, at least with the modern Constitution, that the Constitution operates within those bounds. Although Jack has explored, Mark has explored this problem of constitutional evil about what happens if you get stuck with a Constitution that does not fall within those bounds. The people have made, in fact, choices that we think are not just unwise or bad in various ways, but legitimately evil kinds of choices, and what would be the proper course of action there, which raises, I think, challenging and difficult questions and different kinds of questions, whether you're an office holder who's taken an oath and has been willing to take an oath in the way that Chris emphasizes, or whether you're an ordinary citizen who lives under such a regime that seems quite troubling in some fundamental ways. The other point that Chris made is about, in addition to this question about sort of the authority and how we all think about the quality of the constitutional decisions that people make, is also this question about whether or not the Constitution referring to this Constitution in distinctive ways ought to rule out the referring to these kinds of traditions, as he characterized it, as being constitutional in a meaningful sense. So we reserve the term Constitution to talking about the text and things that might be directly interpreted from the text, as opposed to thinking about these unwritten features of our political system as a whole. And this is something I've sort of puzzled over myself in a sense of sort of what's the utility of talking about these in constitutional terms, and is it helpful to use that kind of language in referencing this material? And I think in part it is in various ways, and I think it's probably worth. And so I want to stick with the idea that we should refer to these as constitutional and features of our system, and not just as pure traditions that are something else and outside the Constitution whole hog. So I'm resistant to wanting to reduce the Constitution down to just the document and the things that arise directly from the document, in part out of recognition about the fact that there are indeterminacies in the Constitution in places where we need to make the Constitution more concrete through practice, and recognizing these as one way in which we have settled these open constitutional questions that arise from the text is important, but we need as well, I think, a way of distinguishing between things that we think sort of flow directly and cleanly from the text, as I try to sort of identify through interpretation, and these things that require some judgment and choices about how we're going to implement the text in practice. It's also true, I think, that there is utility for the political system, and maybe this is my political scientist element coming out, but my starting point, I think, in thinking about this was not so much political science as thinking about how 19th century American statesmen talked about our constitutional system. Is recognizing that constitutions serve functions within the political system as a whole, as the British recognize, since they don't have a written constitution to refer to and a document that claims to be this constitution. Instead, they identify their constitution through a set of functions that are performed within the political system. And we, of course, also have those functions that need to be performed, and it's appropriate to recognize the things that serve those functions as being part of our constitutional life and part of our constitutional practice. We don't want to confuse them with the text because they don't have the same kind of legal authority. And there I want to make a sharp distinction between what has that kind of legal authority and, as a consequence, what the court should be careful not to entrench in law in various ways. But I think it's highly appropriate to recognize some of our practices and traditions as being as essential to the operation of our system as things that emerge out of the law and the text. And one feature of our very recent politics, of course, is that it's pointed to one particular aspect of that which comes through all our conversations about norms. That constitutional norms are one version of this, in which we recognize there are informal features of how our Constitution operates that are essential to how the constitutional system behaves, including essential to the preservation of the constitutional system in the kind of normatively attractive and meaningful ways that we want it to be preserved, but can't be traced back and should not be enforced through law, can't be traced back to the constitutional document as such. But those constitutional norms serve important constitutional functions, and I think it's appropriate to characterize them in many cases as constitutional and not simply set them aside as being something else, and doing so also suggests maybe they aren't that important anyway. And so if we violate them and break them, maybe nothing bad will come from that. I think recognizing their the way in which they're integral to the functioning of the political system also emphasizes, I think, how important they are to the system and how much they serve the constitutional ends we're trying to serve. And so I think trying to relabel them and set them aside as merely traditions will tend to discount and undermine that. Finally, with some of the specific issues that John McGinnis raised, I just want to mostly acknowledge them. I think he's absolutely right to think that one of the central issues currently facing originalist theory is thinking about precedent and how that falls within the system. I think I want to write more about that. I certainly said some things in my early work, which I think are still mostly right, but it's worth trying to elaborate that much more. And I think it's something the courts will very much be struggling with, as well as theorists. And if originalist theory is going to both provide any kind of meaningful guidance to judges who might be inclined to follow such guidance, as well as being, I think, a serious and useful theory and not, as John characterized it, just a purely academic interest, one has to think seriously about what to do about non-originalist precedents and how to approach them, what their status should be understood to be within the system as a whole, and the like. And I should just highlight, I think the sort of thing that sort of runs underneath a lot of what John said is that in his own work, he has emphasized that the construction zone, as he understands it empirically, is a much more narrow space than others. So Jack does have a very expansive vision of empirically how much space the Constitution leaves for creative constructions of meaning. John thinks it's much more narrow, in part because of an existence of a whole set of default rules about how we ought to deal with imprecision and indeterminacy and vagueness in law that helps confine that space and makes fewer choices necessary because we have mechanisms that are sort of built in for what we ought to do when we confront these contexts in which are particularly vague. And relatedly, which John sort of touched on, but I think is a interesting point, and one I have not yet fully sort of thought through myself as to how to think about it, that comes up in the impeachment context of high crimes and misdemeanors and like, but also comes up in plenty of other contexts, is to what degree is the Constitution almost entirely a lawyerly document, such that we can read it all through the lens of traditional legal background, which may give it a lot more content. And as John thinks, sort of then shrinks the construction zone significantly because maybe things that look imprecise or indeterminate become much more precise if we recognize, in fact, there's an elaborate legal background behind particular phrases in the Constitution and the like, and if we read it all as being a very lawyerly document. It not only potentially affects how we interpret particular components of the document, But it may also have implications for thinking about the method of how we go about interpreting documents. It may have implications for thinking about those normative foundations and who is part of the reference point when we think about what the public meaning of the Constitution might have been, and the like. And these have been important moves in his own scholarship that I think does put some real challenges on the kind of approach that I want to take. I think there are ways, I'm usually try to reconcile things rather than just tell other people they're wrong. So I hope there's ways of trying to bring everything together and reconcile in various ways. But I think if I return to the originalism stuff and try to write it, one of the real things I will have to do is grapple very seriously with some of the work that John has been engaged in really pushing this emphasis on the ways in which the Constitution is best understood as a lawyer's document all the way down, and all the kinds of implications that follow from that, both for originalist theory, but also for specific work in interpretation. So let me stop there. So thank you very much.
So why don't we begin here? We have about 20 minutes left. I first invite the panel if they have some for follow-up questions for one another or for Keith.
Follow-up questions. Okay. I had an answer to John.
Answers.
So John asked, what should we do about precedent? Here's what we should do. We should do what Justice Stevens suggested the day he retired. So he said, we shouldn't resurrect the Privileges or Immunities Clause because the original meaning of the clause is not clear enough to dislodge 137 years of precedent. So what we should do is look at all the considerations, policy considerations, reliance interest, all that stuff, and that increases the weight of the consideration of correcting errors, and it increases the level of clarity you need. So this is something that Justice Barrett said in one of her earlier articles. Where is it? She'll think carefully about whether she's sure enough of her rationale for overruling, for upsetting. Justice Breyer said, you better be damn sure before you do this kind of thing. Justice Jackson. So anyway, that's what she'll do. So more epistemology, please. That's not a question.
No, but a helpful comment. Professor Levinson.
Wonderful panel. Two quick comments. The first has to do with constitutional evil, and the question is really very simple, especially for something called the James Madison program. Was James Madison correct in describing the allocation of voting power in the Senate as an evil? He said it was a necessary, lesser evil because it needed to be ratified in the Constitution, but to my knowledge, he never recanted with his description of that aspect of the Senate as an evil. The second and more important question has to do with popular sovereignty. Is popular sovereignty a kind of Kantian regulative ideal that we simply have to assume is the foundation of our system in a way that an earlier generation assumed the divine right of kings? And I assume that for those of us who are secularists, the divine right of kings could not possibly have been empiricized, but you can certainly say it was a foundational norm. And I have the same view about popular sovereignty, that Edmund Morgan described it as a fiction. And I can kind of understand an argument that there might be varieties of popular sovereignty. We're more along the line, say, than Vladimir Lenin, both of whom speak in the terms of popular sovereignty, but that ultimately it cannot be empiricized. It is ridiculous to view 1787 as expressing the substantial will of a majority of the American public, most of whom were stopped from participating. We don't even have to go down the obvious route of slavery with regard to that. I concede, I agree completely with Keith and with John that it is a regulative ideal. What I want to know is how, in fact, as a political scientist, one can actually give it sufficient descriptive weight to persuade anybody to change his or her view on a matter of genuine substance, where one believes one is talking about justice or injustice, good or evil, or even social welfare versus, suboptimal politics.
So maybe I'm obliged to respond at least first to this. So I have to revisit, I guess, what Madison said exactly about Senate apportionment being an evil. My inclinations certainly say it's not an evil in the way that I would tend to think of the kind of constitutional evils that occupy sort of Mark and others in thinking about this. I think of sort of a commitment to slavery and the like, right? It may be something that is normatively not preferable, but hard to, I think, characterize as an evil. But maybe there's something more specific there as to what he's thinking about that would make me think maybe there's something more there than my initial inclination would suggest. On the popular sovereignty thing, so yeah, I totally think, right, the best way to think about it is a kind of regulative ideal. I'm perfectly happy to characterize it as a kind of fiction about how the system works or should work. But I think one feature of both American politics and I think how sort of ideas of popular sovereignty would work is there is ongoing contestation as to how best to operationalize some ideal of popular sovereignty in practice. And we've seen lots of contestation of that over time. We've seen modifications about that over the course of American history as to how we think that might play out. I have some preferences of my own about sort of better and worst versions of that, but I don't think it's a fixed feature of how the American political system works. But on the other hand, American politics revolves around the idea that this is the core commitment, and then the question is, how should you operationalize it? And then we can argue about how best to operationalize it in practice. And I think that re-emphasizes the extent to which this regulative ideal, the fact that we recur back to that rather than saying, well, there's something else that just trumps that. We don't need that. The touch point is not some notion of popular sovereignty, but the real touch point is some notion of justice or something else, and such that we can just have a Judge Hercules who tells us what justice is, rather than ultimately you have to be able to tie it back to, well, what did the people endorse as their own vision of justice through whatever mechanisms of endorsement we at least took at the moment of being adequate to serve this function.
Other comments from the panel on that topic before we move on?
Let me just say,
John.
let me add to that. I think Keith is right about that. I think we do have a concept, and I don't think it's fair to say it's simply a regulative ideal. If the founding was even more defective than I think Sandy thinks it was, we might really have problems with the Constitution. It's not that it was perfect at all, but that we think that it has, we think that it was, had some very strong features that led to a pretty good Constitution, and then we, over time, corrected it through other exercises of popular sovereignty. One of the striking facts about Keith's book is it's so important that we can exercise our sovereignty now through the amendment process. Now, we could have a debate about whether the amendment process is too difficult or not, but it's essential that we have an amendment process through which we can exercise our sovereignty now in a concrete way, So I don't think, at least I don't accept that it's just a regulative idea. It's also a concrete idea, imperfectly realized over some parts of our Constitution, but I think progressively here, realized better over time. We now accept there were problems, process defects at the beginning, but now we've accepted everyone into the polity. One of the striking facts about that is very few people argue that we should have another constitutional convention and remake our sovereignty today, which actually suggests that, well, maybe it wasn't so great back then, but maybe it's better than what we might do today. So I do think there's a concreteness to it that should be celebrated, even with its defects, not just an ideal.
I was just going to, in part inspired by John, but advertise two books they overdue, and I'm trying to rework, and hopefully will come out. And Yale, I guess, will get credit or blame when they appear. But one of which is trying
credit
to
if they're good.
Credit if they're good. No blame if they're bad. Then they were sort of holdovers from Princeton at that point, and yeah. But one focusing on sort of 19th century arguments about the nature of democracy in America, where there is, I think, a striking recurrent feature across more than a century of people both being deeply committed to the ideal of popular sovereignty and democracy as being what ought to be true about America and how we ought to guide ourselves, but also deep disagreements about what that means in practice and how to implement it, as well as a remarkable amount of fear that it might not work. and so lots of ongoing anxiety about whether or not this is actually going to be a functional system of government, which I don't think we've quite lost. In another project focused more on the idea of constitutional crisis, part of what I emphasize there is one feature of having popular sovereignty as the regulative ideal of the American system is it has then at the very heart of the constitutional enterprise a kind of very revolutionary notion. And we have not seen that so much at the federal level. There's not a lot of support for the idea we ought to have another federal constitution. Constitutional convention, people not that enthusiastic about the prospects of us doing as well as they did in 1787. But we have had moments in state constitutional history in which people do think we ought to have a new constitutional convention and have called conventions and just declared we have a new constitution then as a consequence of that convention. And one of the interesting features of that kind of history is it really emphasizes that question of that there is no clear way of operationalizing popular sovereignty, but also no clear way of knowing when the popular sovereign is actually spoken, right? Who gets to claim that mantle? And it's always contestable and contested in the moment. And so an extraordinarily risky thing to have embedded at the heart of your constitutional system. But I think there it is, right? And it is true there. And so I think we have to recognize, even as a regulative ideal then, that it is like I said, sort of fundamentally kind of revolutionary kind of concept to embed within your constitutional order that could raise its head at any sort of moment and expose just how revolutionary it is.
I did want to say a word on behalf of the Senate. So an important distinction is between popular sovereignty and majoritarianism. So the right of the entire people to do something is one thing, but the right of 50% plus a person to do all kinds of terrible things to the minority is very different. So when you've got a bunch of states who have veto gates over whether they're going to participate, you've got to have something like the Senate. There's some great stuff about the importance of the anti-federalists to the founding generation that Keith makes in his book. And I mean, essentially what he's saying is, the anti-federalists more or less decided to accept Article 7 on their own. They didn't have to accept that this whole process we're having about ratification conventions is actually a way to do a constitution. But once they participate, Melanchthon Smiths of the world, they participate, they extract some kind of promise of a Bill of Rights as the prize, and then it became the act of the entire people. But today, getting, especially in a divided republic like we've got, I think it's really, really, really important to recognize that distinction. The Constitution probably has too many veto gates, but we don't want to, just eat the rich.
Another question. Here's the.
Thank you very
the
much
mic.
for just a wonderful panel. And this is sort of another James Madison kind of question, dealing with, what is constitutional conservatism? If we decide, as I actually agree, that the Constitution has been good for the United States for the past 236 years, aren't we saying that there is a set of historical practices which have some bearing to what the historical practices were thought to be in 1787, but may or may not be identical to them? And it's those historical practices, development, to anticipate and make a commercial for the next panel, that matters. So to take a concrete example, if the Electoral College has been good for the United States in the sense of it's a rule that keeps politicians' hands off the system for electing president, what's been good is a practice where the electors exercise no discretion, and not the anticipated practice where the electors exercise lots of discretion. So I'm wondering whether we have a debate here between radicalism, get rid of it because it violates first principles, conservatism, the institution as it's been for 236 years, or reactionaryism. This is what it was supposed to be 236 years ago, and whether or not it's good for America or not, that's what James Madison thought, that's what we should do. Question mark.
So Keith, do you think Schiaffolo is a disaster?
I don't think it's a disaster. Imperfect. I have a piece on Schiaffolo in the Cato Supreme Court review of that after that term, in which I criticized it but said it could have been much worse. And so and I think one kind of question is sort of what the Schiaffolo being the case in which the Supreme Court was asked about some of the consequences of the Hamilton electors after the 2016 election, in which there are a set of states that have purported restrictions on whether or not electors can cast free ballots. And so can you fine electors for breaking their pledges about how they were going to cast their ballot, or could you even remove electors if they attempted to cast a ballot that violated their pledge and replace them with an elector that would faithfully uphold their pledge? And the court accepted the constitutional validity of these state statutes that purport to restrict electors. And so I think that so I'm not very enthusiastic about the idea that the state legislature can actually do that, and so that's where I think it's a mess. I think on the other hand, I think the broader upshot of trying to maintain the tradition that we've developed in which electors don't actually exercise discretion is the right one. In some ways, it's just unfortunate that the court was even forced with the question, because I don't think there was a good answer the court could have provided. And it's one of the challenges, I think, of getting the court involved in something that is fundamentally a constitutional construction and a tradition that exists outside the legal framework, but is a question about how to constrain the exercise of discretionary authority. Once you have framed it in terms of a judicial question, you're almost necessarily going to wind up with pretty imperfect interventions. They're going to screw it up to some degree. It's the downside of the expansion of the court in the ways that the Political Foundations book sort of emphasized. So I have a piece in the Arizona Law Review on faithless electors, in which Sandy thought I was very wrong about, but which I denounce the Hamilton electors at great length because they violate this tradition. But whether or not states then should be understood to have the authority to constrain the Hamilton electors, I think, is a different challenge.
We have time for maybe one more question.
Yeah, hi. I think I'm going to push on the question Jack asked that you already declared you weren't going to answer. So feel free to do that again. But it's about the relationship between judicial restraint and originalism. Because when I studied your book with you, it was very clear to me that part of the normative impulse there was to find a way to restrain judicial discretion and judicial policymaking. And today, this conversation about, well, what do you do with precedent has sort of landed at a place, well, like judges will have a lot of discretion over what they make of precedent. If they have really good reasons, they'll throw it out. And if not, then we'll keep it there. And that seems to me to have sort of untether or decouple this idea of originalism, which seemed to be first, when you advanced it, and many conservatives advanced it, about judicial restraint. It doesn't seem to work that way anymore. So I was wondering if you could speak to that.
Yeah, fair enough. So I recently had a session with a new set of grad students who about some of the originalism stuff, and I don't know what their reaction would have been to whether this is how I thought about it now, and that the conversation. I do tend to think that the restraint has been de-emphasized in some of my work, and we should separate out the restraint a little bit, or disaggregate what the components are a little bit in terms of whether or not we should be thinking of it in terms of constraining judicial discretion about how they make decisions, as opposed to deference to elected officials and how they made decisions. And so I tend to think that originalism is the right goal that judges ought to be focused on, but I'm not necessarily optimistic about how well originalism will in fact tie hands of judges. I think there's a lot of early originalists who were very optimistic that if you adopted an originalist method, it will sort of take away a lot of discretionary possibility out of hands of judges. And I think we're still going to wind up with lots of disagreement about what judges in fact do in practice, no matter how, even if they're all in good faith trying to be good originalists. It gives us space to criticize how they're doing it, but I think we can't be overly optimistic about how much it's going to reduce that kind of discretion. There's a second kind of question, though, about how deferential they ought to be to other branches of government. And on that, I'm more supportive of than, for example, Robert Bork was, of the idea of courts being of actually enforcing the terms of the Constitution against elected bodies when they violate them. And so to the extent that judges conclude that the meaning of the Constitution has been violated, they have a responsibility to say that. So that leads us to a kind of activism and interventionism. But you're right, on some of these questions about, okay, what do you do when you've inherited non-originalist precedents? For example, what do you do when you're called upon to decide the faithless elector kind of cases? Or I think, for example, the Section 3 case, at least some components of the Section 3 case, it forces judges into a position where they've got to make some discretionary choices. And I think that's an unfortunate feature of the kind of political system we have developed, but I think it is a feature of our current political system. And then we're sort of in an imperfect world about, okay, how should judges best navigate that, given those choices in front of them? And so when the court is now being asked to resolve the faithless electors case, my sort of hope in some ways is that they just don't screw it up too much. But it's you're in an imperfect world in which really that's a case they shouldn't have been having to try to answer it all. Preferably, I think, because like you said, I think almost any intervention is going to be an imperfect one.
I'll just add one point about that. So I think there's another way that we might get judicial restraint from originalism, which goes back to the question of, well, what is judicial power? It might be built within originalism. I think actually two members of this panel think that, at least with respect to other branches, the judiciary should only intervene when it has a sort of clear and convincing view that it's right. And so there is this rule of evidence there. And I think that's the most promising way to reconcile originalism with judicial restraint, because the other ways really are somewhat orthogonal to originalism. They bring in some other political theory you have and don't look at the document, but the document itself may contain those answers, and I think that may be one way of bringing about a reconciliation of the original impulse of originalism, as it were, in its current state.
It has been my experience, by the way, that the originalist judges on the court, and not just the originalists, the non-originalist judges, always think they have clear and convincing evidence that they're correct. So under that sense, this would simply reduce to the system we have now.
Very briefly, I want to advertise a panel from 8 years ago. What is the relationship of originalism and judicial restraint? Which
You should go back in time and watch that show.
Yeah, well, I did for the preparation, but Keith had some extremely insightful, concise comments. I have some rambling ones. Earl Mullins and David Open. So.
Well, we can't go back in time, but we can thank our panelists for stimulating conversation.
Good morning, everybody. I'm Alan Patton. I'm the chair of the politics department here and Keith's longtime colleague. This is a panel on another theme in Keith's work, American political development. And we have 4 panelists. We're going till 12 noon. We've got to stop right at 12 noon because Mark has a parking meter that will run out at that time, and I have another meeting that I have to get to that starts at that time. So we're going to we'll have presentations of between 5 and 10 minutes from each of our 4 panelists. Because there's such a beautiful program that has been produced for this event, and there are full biographical details on each of our speakers. I won't read out the full bios, but let me just briefly say that our first speaker will be Mark Graber, who is the Regents Professor at the University of Maryland Carey School of Law. Like Keith, Mark has a PhD in political science from a well-known university in Connecticut. And I will just add that his most recent book is Punish Treason, Reward Loyalty, The Forgotten Goals of Constitutional Reform After the Civil War. Our second speaker will be Tara Lee Grove, who is the Vinson and Elkins Chair in Law at the University of Texas School of Law. Tara has published with a number of prestigious law journals, including the Harvard Law Review, the Columbia Law Review, UPenn Law Review, and NYU Law Review. And she has received awards for both her teaching and her research, and recently served, I believe, with Keith, if I recall correctly, on the Presidential Commission on the Supreme Court of the United States. Then thirdly, we will hear from Sandy Levinson, who is the W. St. John Garwood and W. St. John Garwood Jr. Centennial Chair in Law at the University of Texas Law School, and also Professor of Government in the Government Department at UT Austin. He is, I should note that he taught here at Princeton from 1975 to 1979, and his most recent book, co-authored with Cynthia Levinson, is Fault Lines in the Constitution. And then finally, we will hear from Emily Zakin, who is an associate professor of political science at Johns Hopkins University. She received her PhD here in our department and had Keith as her supervisor. So we're really happy to have Emily back. Her book, Looking for Rights in All the Wrong Places, Why State Constitutions Contain America's Positive Rights, appeared in 2013, and she has a new book co-authored with Chloe Thurston called The Political Development of American Debt Relief, which will be published in June of this year. So we'll start with Mark, and then we'll take it from there.
Well, thank you very, very much for all of this. When the right seeks to defund the left, they zero out Planned Parenthood. When the left seeks to defund the right, we come to the James Madison program and eat your food. And we can tell Robbie right now, I speak for a great many of us, we're happy to do 4 for the price of 3. There is a genuine challenge in doing, can we honor Keith? We're really honoring the whole community, of which Keith is just a vital part of. So many of us have built on his scholarship, and he has, both been a foundation and building on our scholarship. If we did a picture of the scholarship we did, and Keith's contribution was blue, there'd be an amazing amount of blue in the picture, and blue would appear in an amazing amount of scholarly pictures. But there'd also be a lot of red for Tara, a lot of green for Emily, a lot of purple for Sandy. And part of the thing is teasing out what the blue is, and in some sense saying it may not be that interesting to do so, is to talk about the picture. So what I want to do is talk about the blue a little bit and what the picture looks like. So when Keith started, I think constitutional arguments outside the court really was sort of the form of, look, Ma, I found a senator making a constitutional argument. Isn't that wonderful? Hey, Grover Cleveland once said due process. Wow. First thing Keith did was insist on elbow grease and set an exceptionally high standard, which his students, to their credit, have followed, for what it means to truly investigate constitutional arguments outside of the court. Second, in doing so, he said it's not simply, look, Ma, these arguments have structure. It's important not simply to report on them, they exist, but to analyze them. They play functions similar to constitutional arguments inside the court. There's a durability to them. There's a stability to them. They're not simply, again, expressions of preference. Turns out, Keith has said, they're not simply the arguments courts are making. You're seeing arguments on the tariffs, on protective tariffs that are constitutional arguments. They're not being duplicated in the courts. Keith opens up a great many issues to us because he points out there was sometimes on abortion, President makes constitutional arguments, Congress makes constitutional, the court makes them, and some things like impeachment, and for that matter, the tariff, the constitutional arguments appear almost entirely outside of the courts, and our case books are remiss when they say this is, American constitutionalism, and they do not cover more than half of the constitutional arguments they will encompass. And by the way, it's not simply law, political science, because a great many lawyers go to work for the OLC. They go to work for Congress, and they are not once exposed to the constitutional issues they will be considering. Keith helped expose us to them. And Keith also raised, through interpretation and construction, the possibility that the arguments were differently structured. Now, I'm inclined to think, as a great many, that distinction doesn't quite work for me, but in thinking about it, where I think Keith is right, is in a Phil Bobbity sense, that a great many constitutional arguments outside of the courts have a different structure. we might say different modalities. It is permitted for a member of Congress to say, I'm following the party platform. I'm following my constituent. These are modalities of arguments available to congressmen that are not really available in that form to judges. It may be, and I think this is part of Emily's contribution, that, I'm going to sort of merge Keith and Emily here, that we might think that constitutional arguments work differently. So take proportionality. One of Keith's pieces, early piece, said that the question of how necessary a national bank is a constitutional question. But it's not a constitutional question for the court. What the court should be considering is merely, did Congress do this for the public good? What a member of Congress should be considering is, given all of its impacts on the world, does this serve the public good? So we can imagine with sort of early rights, where the understanding, I believe, of gun rights was if it was in the public interest, a legislature could do it, but a legislator could not stop with saying, for constitutional purposes, this is in the public good. The legislator had to consider, well, what's the impact on the right? What's the impact more generally to decide whether it's constitutional? So there are a different set of constitutional issues that a legislator had to consider than a court. Now this, as Jack would point out, is not exactly Keith's interpretation construction, but it's one example of the different ways people built on that to develop their own, and they could not have built on this without Keith's work. So to consider one last feature, and here really I am merging Emily and Keith, the positive rights tradition in the United States. That one of the things the Constitution, federal government has a constitutional duty to protect citizens, and I've argued that protection includes guaranteeing the resources all citizens need to flourish as citizens. Well, it turns out that, I'm actually going to honor this, it turns out that a court can enforce the equal protection component. You have to protect everybody equal. You can't provide protection for A and not B, particularly when you're on racial lines. But that's not the obligation. The obligation, sorry, Chief Justice Rehnquist, is to provide a level of protection for everyone. If government doesn't protect you, 19th century law says you no longer have allegiance. But the level of protection and how to provide it is for the legislature. It is a constitutional duty, as Keith and others remind us, but it's not enforceable by the court. So, said something at a celebration of Sandy, I think it's equally true of Keith, that we judge people and scholars not simply by what they write, but what they write makes possible for us to write. And so this is a celebration of Keith and a celebration of ourselves as how much Keith has written that makes it possible for us to write. Thank you.
So thanks so much. It's such a delight to be able to do this and honor Keith. And I look forward to honoring you, Mark, at an event just like this at some point. So as you heard, in 2021, Keith and I served together on President Biden's Supreme Court Commission. I'm going to say more about that commission, but first I want to say a few words about what in Keith's scholarship made him such an ideal person to be on the commission. You've already heard a few references to his work on the political foundations of judicial supremacy. So just to underscore how much this changed legal thinking, for decades and decades before my time as a law professor, legal scholars were obsessed with what Alexander Bickel called the counter-majoritarian difficulty. Judicial review was this anti-democratic force where lawmakers would enact something and then judges would come in and kill it. And so the normative question for legal scholars was, how can we justify that? Well, political scientists like Keith and Mark came along and said, why would politicians ever listen to a truly counter-majoritarian court that is completely antithetical to the way political actors work? So they reframed the question and said, why do politicians ever listen to the courts? And what they came up with was this idea that actually judicial review, judicial supremacy, judicial power is all politically constructed, or largely politically constructed. And any leeway the judges have to do counter-majoritarian things are given to them only because a lot of what they do, even when they're striking down laws, is stuff that is quite beneficial to the political branches. So Keith gives these wonderful historical examples like Grover Cleveland, who agreed to an income tax in exchange for tariff reform, and was quite pleased when the U.S. Supreme Court later struck down that federal income tax and said, no, can't do. So this is just one example of many where political actors rely on the judiciary to do stuff. Another area of Keith's scholarship, constitutional norms. Keith must have had a crystal ball in 2013 when he started writing about constitutional norms and conventions, because up until 2015, 2016, when a certain presidential candidate came upon the scene and became president of the United States, not many people were thinking about norms. Now everyone is thinking about norms. And many of us have written on this stuff, building on Keith's work from his time starting in 2013. And I want to underscore, when you come into the academy when I did in 2009, the legal atmosphere was completely transformed by the work of folks like Keith. My own scholarship has been informed since the very beginning by Keith's work, and I think we've all been learning from him. This is why it kind of makes sense that he's actually moving to a law school. But I want to say he's been influencing law professors even from his time here in Princeton. Now, all of that is just on the theoretical side. As my Grover Cleveland example suggests, Keith's work is also extraordinarily rich history. If you want to find the history not only of political support for the judiciary, but also court-curbing attempts, whether it be taking away jurisdiction, court expansion, or court packing, Keith's work provides this remarkably rich history and remarkably accessible history. And for all these reasons, he was a logical person to serve on the Supreme Court Commission. Now, I'm going to say a little bit more about that work, but I just want to say I knew Keith as a scholar from afar because I'd been reading his work since I started as a fellow at Harvard in 2007 and then started my first academic job in 2009. But I didn't actually know him that well as a person until we served on the commission together. And I think people kind of referenced this last night. Those of you at Princeton know this. Keith is the ideal colleague. He's extremely even-keeled. Not everyone on the commission was. He's fun to work with, fun to talk to, tries to bring people together. And when you as a commissioner say, could you please do this work, he actually does it. And those of us who've served on committees in law schools and other groups, we know that's not always true, even especially from some of the best scholars. So he was delightful to work with, and I'm so grateful for that because people differed in their work ethic on the Supreme Court Commission. Now, impact of Supreme Court Commission. Of course, any scholar's ideal is to actually have a real impact on the world with their scholarship. And some people are thinking right now, but the commission did absolutely nothing. So what kind of an impact was that? As I tell my students when I'm talking about the commission, Many presidential candidates in 2020, at least on the Democratic side, talked about court reform. Let's expand the court. Let's change the court. Let's strip jurisdiction. President Biden said, I'm going to create a commission. Now, that actually is an impact, right? It's a way for politicians to kick the can down the road. So that was a short-term impact. I actually think the commission's work had other immediate impacts and potential future impacts as well. Now, in the short term, the commission's mealy-mouthed report, and yes, it was pretty mealy-mouthed, well, you could expand the court if you'd like to do that, or you could just not pack the court, and people really do say court expansion if they like it and court packing if they don't. You could strip jurisdiction, but maybe that's not a good idea. The Supreme Court could have ethics reform, maybe, just maybe. Could you please do that, Supreme Court? Because Congress isn't going to do it. So that's kind of what the Commission's report said. Why did that have a short-term impact? So I think in the short term, building on what Keith and others have written about the political foundations of judicial power and judicial supremacy, in the short term, the very mealy-mouthed nature of that commission's report gave the Supreme Court kind of a license to do more stuff. And regardless of your normative views, it made the Dobbs decision reversing Roe versus Wade and Planned Parenthood versus Casey easier because there was no commission report saying we should immediately take away jurisdiction or expand the court. So that's probably true in the short term. Long term, I actually have a lot of worries about the mealy-mouthed nature of the commission's report. Now, there was no question, I think, in the minds of anyone, and including political scientists, that no matter what the commission said, nothing was going to happen, right? This was a time when there was a divided Congress. President Biden was not a big fan of court reform. That's my guess. I have no personal knowledge of this. But there was certainly not enough political support for the Democratic Party, even if there had been a lot of support among all Democrats, which there was not, for court reform. So no matter what the commission said, nothing was going to happen immediately to the federal judiciary. But the commission could have made taken a much firmer stand against court reform, and did not do that either. And so one worry that I have, or many of you would view this as probably a good thing, but one worry that I have is that the very mealy-mouthed nature of that commission's report, this bipartisan commission, will make it much easier, not for a President Biden, but for a future president, name the one you are most concerned about being president in the future, for a future president to engage in court reform, because the commission's report did not explicitly take that option off the table. In fact, gave a lot to those who want court reform. And that leads me to my normative comments, both about the work of the commission and also about Keith's scholarship. We currently live in a world where political leaders do defer a lot to the federal judiciary. And Keith mentioned this earlier today. His work definitely tells us, yes, they defer a lot, but the normative questions remain. Is that a good thing? So one question, of course, is should the federal judiciary accept these invitations from the political branches? Keith wrote a wonderful article entitled, "Interpose Your Friendly Hand." Should the courts actually do that? Or should they say no, maybe to preserve their own legitimacy? Should the courts say no in order to put more pressure on political actors to actually engage in constitutional construction? One can look over many decades, even centuries of legislative debates. I have, and there were far more discussions of constitutional issues among lawmakers and politicians in the 19th and early 20th century than you see today. There are still some today, but not nearly as many. And so the more you rely on the judiciary, the less the political branches may feel obligated to do. But I also want to say this. We often sort of separate out political branch power and judicial independence, but I don't think we should. Because as Keith's work has taught us, the very power and independence of the judiciary is politically constructed. The judiciary relies on Congress for jurisdiction, for funding, relies on the executive for enforcement of judicial orders. And so I think we should stop asking the question, well, Should we just leave everything up to the courts? Because judicial power, judicial independence is only possible if we have a functioning president and Congress. Thank you.
It would be daunting to speak about Keith's contributions to the study of American constitutionalism if I had a full hour, or indeed longer than that, but I don't. I will try valiantly to stay within my allotted 10 minutes. So let me make 3 hasty points with regard to what I have especially learned from Keith's invaluable work over the years. First, one of the central myths of the Constitution is that it is a well-designed machine that works by itself. It is the equivalent of what is sometimes called a teacher-proof curriculum, designed so well that the identity of the teacher simply doesn't matter. But of course, the Constitution is not such a machine. As Jill Lepore has noted, the orrery in Philadelphia, illustrating the movement of the planets in their orbits that some compare to the Constitution, rapidly broke down, never to be repaired. Whether the American political system has broken down, all can agree that it is composed very much of identifiable individuals and political parties with all sorts of desires and interests of their own. They may, to some degree, be stymied by the institutions established in 1787. I certainly agree that is the case. But that doesn't mean that they are without genuine agency. Constitutional hardball, for example, has become a way of identifying pushing at the limits of what might be thought to be constitutional conventions or constitutional constraints, not to mention treating some constraints as mere Madisonian parchment barriers to be ignored. So one central question is exactly why ambitious politicians will submit to judicial decisions that place barriers in the way of achieving their goals. That, of course, is the subject of one of Keith's major books. And he demonstrates, at least to my satisfaction, that presidents and members of Congress submit themselves to judicial decisions because they believe overall that it is in their interest to do so. Part of the reason he shows in his magisterial overview of every Supreme Court decision testing federal powers is that the Supreme Court has rarely rebuffed truly major decisions by the other federal branches that they're generally committed to. And the story of the income tax is a wonderful story in this regard. As Charles Black suggested many decades ago, a primary role of the court in particular is to legitimize uses of federal power by declaring that they in fact remain within constitutional norms. But the meaningfulness of saying yes requires at least the theoretical ability to say no. It is important every now and then to demonstrate the latter ability. But lawyers especially may greatly overestimate both the frequency and the importance of those naysaying decisions. It is worth noting that any modern analysis of the role that law as an independent variable might play, particularly in executive branch decisions, must take into account the creation of the Office of Legal Counsel, a powerful agency within the Department of Justice that, of course, meets none of the criteria that we usually think of with regard to judicial independence. And it seems to me that this is an insight of political science that I hope very much that Keith brings to the Yale Law School and all other law schools that grotesquely overestimate the importance of the United States Supreme Court and underestimate the importance of many other agencies and institutions within the American government as it actually operates. That is point one. Point two, one of the greatest
immediate impacts that Keith has had on my own thinking comes from one of his early books, Constitutional Construction, where he informed me that Southern members of Congress pronounced the tariff of 1828 not only abominable, but in addition, unconstitutional. After all, its purpose was not simply the neutral raising of federal revenues, but rather using the protective tariff to aid developing northern industries at the price of southern agricultural interest. That is, it basically violated the command that congressional legislation be for the general welfare rather than merely sectional welfare. To put it mildly, this argument sounds extremely odd in a modern era where all political scientists and most lawyers describe politics as the endless struggle among self-interested interest groups to capture the machinery of government to use for their own purposes. Almost no one takes seriously the possibility of genuine commitment to something called the general welfare. That, I think, is a very important point. Indeed, I think it is illustrated quite literally today when one of the leading stories is the passage by the state of Florida of a deliberate anti-climate change policy, while at the same time I have no doubt that Florida will seek all sorts of federal disaster relief when the next predictable hurricane destroys Miami. My own view is that would be hard to defend under general welfare, especially if a state engages in morally hazardous policies. But as I say, this is a bizarre way of thinking in the modern world. And one of the things that I learned so much from Keith's book is that it was not a bizarre way of thinking, say, in the 1820s. So then there's the third point, which has already been adverted to, which is the Electoral College, which I despise as part of American politics, but it is part of American politics. And in 2016, two colleagues of mine at the University of Texas, Jeff Toulis, who also had taught at Princeton before coming to Texas, and Jeremy Surrey, wrote an op-ed in the New York Daily News begging Republican electors to exercise their Hamiltonian prerogative to pick a Republican who might in fact be fit to serve as President of the United States. Let us say John Kasich or Mitt Romney. We did not suggest that there was any duty at all to pick the person who actually won the majority, that won the plurality vote, but rather we conceded that a Republican ought to become president, but not Donald Trump. Needless to say, we did not succeed. The following month or so, there was a conference at the University of Texas that Keith came down to, in which he suggested two things, and he's already adverted to this. First of all, that we were faithful originalists with regard to the original design of the Electoral College, and of course we cited Federalist 68 copiously, that this was the original understanding, this is the original public meaning, that we certainly did not have in 1787 or even thereafter any notion of instructed representatives. Even senators were not ambassadors because, after all, they had full 6-year terms. They could not be recalled by the state legislatures that named them. As all of you know, the debate about instruction was a real debate in 1787, and the people who believed in instruction lost, including with regard to the Electoral College. But according to the U.S. Supreme Court, all of that is irrelevant because we can have instructed representatives in one very, very important institution of the American national government, and that is the Electoral College. So what Keith said, A, is that we were probably right with regard to original understanding, original intent, original public meaning, etc., but that if our very heartfelt plea had been accepted, it might well have triggered civil war. And I think that Keith is probably right. As a political scientist, rather than a lawyer, and I always say these days that in my sunset years, I define myself far more as a political scientist, my original training, than as a lawyer. That I think Keith was probably right as a political scientist, that had our advice been accepted, it would have been viewed as theft of the presidency, and civil war is not to be disregarded. So the question ultimately is whether this is an exercise in living constitutionalism, progressive in this case doesn't mean politically progressive, but progressive development of the Constitution, which requires putting originalism to one side, or whether there is a way by which any originalist can genuinely justify the rejection of Hamiltonian electors.
Hello. I had the enormous good fortune of studying with Keith here at Princeton. He advised my dissertation, and I've long imagined I might get to be on a panel like this, but I assumed it would have to wait another decade or two until Keith was sufficiently close to retirement to win a Lifetime Achievement Award. I'm delighted that I don't have to wait that long, and I consider this a very useful dry run for the Lifetime Achievement panels to come. And I should say my other advisor, Paul Freimer, is also here, and the same goes for you as well, Paul. But I have to admit, I struggled a little bit with what to talk about, because even though we've been relieved of the obligation to talk about constitutional interpretation or campus speech, there's still so much in the realm of constitutionalism and APD. My first thought was to talk about regime theory, how Keith's work has helped us to understand the Supreme Court as developed by and as acting as part of national governing coalitions. And one question I was developing there was about how that holds up now when there doesn't seem to be a single national coalition, but two very polarized parties that are vying for power and trading on and off. But two of my fellow panelists have also contributed to that literature, and I suspected, though I now see incorrectly, that they were going to talk about that. Then I thought I might talk about how Keith recognized judicial supremacy, the idea that the Supreme Court is the ultimate authority on constitutional meaning, not as a fixed or necessary part of our constitutional system, but as the product of political development. In the process, extending work on the presidency done by one of his own advisors, Steve Skowronek. But that's really his only book like that picks up so directly on the work of an advisor, and it doesn't capture the range or scale of his impact either. Then I took Repugnant Laws off my shelf and spent some time crafting sentences about how crucial that book is for making sense of the Supreme Court's role in American politics. How now that that book is out, it really does seem unbelievable that for decades and decades, scholarship on judicial activism and restraint had been conducted in the absence of systematic information about what laws the Supreme Court had actually nullified, and especially which it had upheld. And while I was working along those lines, a friend, also an academic, called to chat, and he asked what I was working on, and I told him about this conference and about why I was struggling. I said, I have such overwhelming admiration for my advisor, and it's kind of awkward to tell him about his own scholarly agenda, and the other people on my panel are such towering figures in the field. And my friend stopped me right there, and he said, no, you're thinking about this all wrong. You should talk about what it's like to be Keith Whittington's student. That's what everyone is curious about. And it is true that over the years since I graduated, I have encountered considerable curiosity about what it's like to work with the Keith Whittington. So Keith, I hope you will forgive the fact that I decided to talk about that today. Now, when you get to graduate school, almost everyone will tell you how important it is to cultivate a relationship with your advisor. And I think most graduate students worry about how to do that, and they keep their antennae up for what kind of person this powerful advisor will warm to and want to mentor. They want to make sure they're coming off the right way, that they're in the club. But very quickly, it became very clear to me that this was totally unnecessary for those of us who worked with Keith. None of Keith's students ever needed to worry about anything but doing our best work because Keith genuinely only cared about the work. He really only wanted to engage with the arguments we could advance, the evidence we could marshal, and the strength of our reasoning. What's more, we never needed to compete for his attention because Keith read everyone's work, returned it immediately, covered in comments, and then spent hours discussing it with each of us. I can't imagine how he was such a productive scholar and still found time to devote so much attention to each of his students. Which is not to say that these long advising sessions were especially encouraging. Sometimes I would check in with fellow advisees about how these meetings had gone, and they'd just sort of look at the ground sadly and shake their heads. Other times, one of us would burst out of Keith's office flushed with success, hold up a draft, and announce, "He said it's plausible." It didn't really get much more effusive than plausible. And I think that speaks not only to Keith's somewhat pronounced reserve, but also to what makes him such an extraordinary teacher and scholar. As far as I can tell, Keith is driven by relentless and pure intellectual curiosity. His question is never, is that topic splashy, or does that conform to my view of things, but always, is that plausible? Can you convince me? In the grad program here, students write, or I don't know if they still do, they used to write big second-year research papers. And the hope was that those papers would contain the kernel of a dissertation topic. And in my second year, I dutifully wrote my paper, and Keith read it immediately, and we scheduled a meeting during which he said, very matter-of-factly, "Yeah, there's really nothing here that strikes me as a workable dissertation topic." I've long thought of that as one of the most consequential and beneficial moments of my career. It's much easier to tell a student, "Sure, this looks promising-ish," than it is to deliver bad news, and I was so lucky to have an advisor who was willing to do that. Then he said, "You could try reading some state constitutions. Not too many people have done that. See what you find." And I went home that evening and I told my husband that I was going to have to drop out of graduate school because I couldn't think of anything more stultifying or pointless than writing an entire book about state constitutions. But I really didn't have any better ideas, so I tried. And in trying, I followed Keith's example of looking around to see what was out there and then giving people enough evidence to convince them to see it the way I did. This is also how Keith taught me to think about my relationship with other scholars, and particularly with those who expressed skepticism. More than once, I showed up in Keith's office full of self-pity about someone who'd been critical of my work. And I think the first time at least, I was hoping my advisor would say something like, "Oh, that's just historians for you," or law professors, or methodologists, or comparativists, fill in the blank. They just don't get our kind of work. But he never said anything like that. He would tell me, "Look, this is market research. People working in that discipline aren't buying your stuff yet. This is your chance to figure out why not and to make it more convincing." And he would meet my protestations of, but doesn't it really seem true that something, 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 with the calm reminder, well, that's an empirical question. Now, I try to impart these same habits of mine to my own students, to welcome critique as an opportunity to improve the work, to try to speak across disciplines, and to replace intuitions with empirical inquiry. And maybe that's a good place to turn back finally to Keith's contributions to the field of American political and constitutional development. Because I think this approach to thinking about the study of constitutionalism as offering a set of empirical questions is one way to understand the reasons Keith's work has transformed the field. Because he approaches the study of constitutional development in this way, empirically, he has avoided the kind of reverent mysticism that often characterized writing in the Constitution. He's pushed back on the idea that there's mundane, everyday politics and then a separate, transcendent realm inhabited by the Constitution and those who interpret it. This is not to say that constitutions aren't different from other political forms, but that what makes them different isn't that the people involved in shaping them are suddenly elevated above their ordinary interests or institutional imperatives. Instead, we can understand constitutional developments by examining how these interests and imperatives interact. And we can do that without asserting that law can't or doesn't constrain people's behavior. That's enabled Keith to think about constitutional practice as much bigger than just the document or the things the Supreme Court has said about it. I think Keith talked about this in his comments this morning. And to think about the Supreme Court itself as part of a much larger system of meaning-making and political change.
His work has opened up a space for a large body of scholarship that has adopted this clear-eyed, historicized, and capacious view of American constitutionalism. That project requires that we do our best to shed the backward-looking and teleological accounts that had long dominated constitutional scholarship. It brings with it an emphasis on primary source work, on really trying to inhabit the worlds of the people we're studying, never to take the conventional wisdom about how things have always been, or our feelings about how we wish they had been, as an authoritative guide to how they actually were. So all of that is obviously much bigger and more important than anything to do with me. But I don't want to conclude these remarks without describing my immense gratitude for Keith's unerring and now long-standing guidance. A generation of students at Princeton has been extraordinarily lucky to benefit from it, and I am so heartened to know that a generation of students at Yale will soon have that same privilege. Thanks.
Well, that was very kind. Plausible. Plausible, yeah. Yeah, unfortunately, the empirical evidence on this is kind of thin. But yeah, yeah, it wouldn't, yeah, I worry about a replication crisis. Yeah, when Emily made this transition of saying that she talked to a friend and said, "You're thinking about this all wrong," I really thought it was going to go a different direction and really should have gone a different direction. But the correct answer would have been, you're thinking about this all wrong because what you ought to be talking about is yourself and your own work, and then there's some afterthought about Whittington and what it has to do with that. So, Emily has not learned the full lesson of how to succeed in academia yet. But, yeah, she's working on it. So some of this, let me say something now, I guess, that borrows a little bit from what I think is always underlies my interest in what the subject matter of the next panel. But this panel very much exemplifies, which is, I value academia deeply and a life in academia and what it offers. And the people on this panel really are the reason why. And people like them who are not here, including Mark and my friend and co-author who is busily trying to deal with a crisis in California. The people on this panel are reflective of the kind of friends I've built in academia and academic careers. They're people who have helped guide me and have prodded me and have inspired me to do additional work. They are people who often disagree with all kinds of things that I think and write and do, and that's fine. That they represent, I think, what for me was always what I expected in academia, but unfortunately is not always true about academia. That is, they're focused on taking ideas seriously and thinking and engaging with people in a sincere and serious way, and perfectly happy to set aside disagreements in order to focus on what's in common and to turn disagreements in productive ways. And I have valued both from their example and from their friendship over time. And my career would not have been, my experience in academia would not have been what it was if not for the people on this panel and people like them who are not on this particular panel. As Alan mentioned, Mark also got his PhD at Yale, also worked with my advisor at Yale, and I believe Mark may have been the first person who reached out to me after I graduated. I did not particularly know Mark before I finished up at Yale, although met him briefly at the University of Texas, where he was teaching and where I was an undergraduate. But Mark reached out to me soon after I graduated and really took me under his wing and helped introduce me to the discipline as a whole. And I appreciated that effort and engagement. And really at the time, while I knew I was very appreciative of that, I don't think fully appreciated just how rare that was and how valuable that was to somebody in my position just starting out and trying to find my way in a discipline in which it was not obvious what the path forward was. One thing I did not fully anticipate, and this is highly relevant to this particular content of this panel, of thinking about American political development and constitutionalism. One thing I did not fully appreciate as I moved from being a student to being a member of the faculty, that as a student, whether you're an undergraduate or graduate student, there are people who are assigned to read your stuff. And when you get your PhD and get out, suddenly nobody's assigned to read your stuff anymore. And you've got to find people who are willing to read your stuff. And that's not an easy task to figure out who that community is, both to write stuff that people might actually want to read, that's not an easy task, but also to figure out who that community of people are who might be interested in the work and how you connect with them and intersect with them and can bring them to your work. And it took a lot of time for me, at least, to find that in the discipline. American political development was a area of study that I was optimistic about when I was graduating, and was all over the place at Yale, but I did not appreciate how uncommon Yale was within the profession more generally. And so really finding people with some of those shared interests and realizing that there were people out there with those connected interests, and that they were all over the country in all kinds of places and across multiple disciplines. And Sandy was a core part of that, and somebody who was at every conference I ever went to, and just seems constantly be on the road. I don't know what he actually does at Texas. And but connected me very much to sort of a set of people in law schools who had related interest, and helped emphasize the extent to which there were real connections between what things that were happening in political science and things that were happening in law schools, and there was a community to be built across those boundaries. And that was extremely valuable to me in sort of trying to think through what I ought to be doing and what my place was within the field. I've certainly had my disappointments with how much American political development has really developed in the ways that I had hoped in political science, but I've also had some real encouragement about things that are being done now and things that have been done over the last many years, both in law schools and in political science departments, and to some degree in history departments as well. And I hope that kind of work continues. Mark said that there's a community that needs to be celebrated with this kind of conversation and with this kind of work. In other context, he's instead said it slightly differently and relatedly, of not always clear where I'm ripping off other people and where they're ripping off me. And there is a set of us, I think, who work in a very common area in which we share ideas a lot. We built off of each other all the time. We're engaged in very close and intimate conversations. That's been an extraordinarily exciting feature of my career and of this place in academia, and I think very fruitful for the development of the scholarship. And I appreciate everyone who's been part of those conversations, because they've been extremely valuable. And as Mark says, it's a community ultimately that you're a part of and that you're engaged in with not only this kind of work, but I think is what we do as academics more generally. And that community has really been invaluable in a personal way, but also invaluable, I think, in producing some really extraordinary insights into how American politics works and has worked, and how the constitutional system works and has worked. And I hope that community continues to develop and find new things to say. The other final thing I guess I would say briefly is a point that Tara made about the commission. Maybe the best thing for me that came out of serving on the commission was getting to know Tara, who I had not previously had a lot of personal contact with, but we worked very closely together on that work. We talked in congressional studies about differences between show horses and work horses in Congress. There were plenty of show horses on the commission. Tara was for sure a workhorse and did extraordinary labors on the commission in actually getting things done, and was extremely diplomatic in building bridges and helping to generate the mealy mouth report that we wound up with a great deal of patience. And she and I shared concerns about just how mealy mouth it was, but sometimes that's what co-authored projects lead you to produce, and what the works of things like commissions required. And so it served its functions, but it was a joy to get to know Tara in that process, and like I said, it's been one of the real benefits for me of serving on the commission. There are many things about serving on that commission I did not particularly enjoy, and would not recommend to others. But there were some upsides, and that was certainly one of them. And Tara's hinted at her own work and why she also was the perfect person to have on such a commission, given the kind of record of scholarship she's produced in this area. And one very admirable thing about that commission, how it was constructed, at least from a pure academics perspective, probably not from a political perspective, was it included a lot of high quality people doing very relevant work who had very useful and important ideas, but probably an indication of the political significance of the commission, the fact that it was full of academics and not full of people with actual political insight and knowledge and weight. But that had certain advantages for us engaged in that work as well. And I think in that sense, and I think Tara's right to bring it up in this context, is that the work that the commission was trying to engage in obviously had very immediate political significance and consequences. It responded to something that was very much in the moment. But the questions it was asking, the kinds of answers it was needing to seek, were exactly the kinds of questions that the American political development field and this kind of area of study try to put on the table. I wish in hindsight, actually, that those of us working in this particular field had asked more of the questions that directly related to some of the questions that the commission had asked. There's not a lot of scholarship out there that addresses some of those immediate things, and so we were feeling around in the dark a little more than one might like. But I think that the kind of questions the committee was engaged in also can be a useful reminder for us as scholars, and particularly us in political science, of thinking about what kinds of scholarship would in fact be useful to answering important questions that actually matter to our political life. And American political development, I think, has engaged in the kind of work that in fact does usefully contribute knowledge in ways that are valuable to actual politics, and the kind of work that the commission was doing is reflective of that the kind of scholarship that some of us are engaged in, I think, is potentially highly relevant to the commission work. And I hope actually in the future I'll wind up doing some of the scholarship I wish had been done before the commission was doing its work, because I think there are interesting questions that emerged out of it that I walked away from the commission thinking, I really wish I knew what the answer to that was, and we don't know yet, and we ought to figure it out. And so, I think there's, I think there's genuine value in what we do in this particular area of study. I find it interesting for its own sake, and that's always nice. But I think it's the extension of human knowledge. We actually do learn new things in this field. And I think we learn things and ask questions that are politically significant and do have value to the outside world and to larger questions people care about. And that's an important thing that we ought to be doing in the field as well. So thank you.
Floor is open for questions. Yes.
So this is sort of a softball question, but I wanted to highlight an aspect of Keith's work that may be underappreciated given the composition of the panels here, although this panel spoke to it a little bit, and that's Keith's influence as a positive political scientist. So, you know, I'm a lawyer, I teach at a law school, so I understand the importance of the normative upshot and the legal upshot of the political science work. But I also want to say it's been hugely influential within political science, and for people like me, whose first instinct, unlike maybe say like Yale law professors, is not to tell people how to fix the world, but first to understand it, right? And so like people who are interested in understanding judicial politics, inter-branch relations, so for me, Keith's seminal Interpose Your Friendly Hand article, his Political Foundations book, and his, I might say, less appreciated Repugnant Laws book were hugely influential. And this is true not only of people in American political development, but also people like me who are like more formal theorists or quantitative methodologists who are you know, interested in the positive political science aspects of it. So I guess I wanted to plug Keith as a social scientist a little more, and not just because those have sort of interesting normative implications for lawyers, but also because they've been influential in political science. Although I wish people like me looked more to people like Keith and Paul, and they looked more to our work. But there's some of that, and it's hugely productive. So I guess if I have to put a question mark at the end of it, so it's not just hagiography, I would just say, you know, what are your thoughts about the prospects of doing the kind of work that you do? You know, the kind of work that's serious about the nuances of the law, sensitive to the nuances of the law, but also rigorous about doing social science. What are the prospects of that kind of work in political science and history departments and also in law schools?
I'm hopeful that there's still good prospects for doing that kind of work. And you know, when I started out, I was not sure as to what I would be doing in general, and in terms of sort of this mix of normative and more empirical, positive kind of social science work. I went to grad school expecting I would primarily to be doing political theory and more normative work in general, and had no interest really in American politics, which seemed quite boring as a field of study, and for me, it's sort of one of these eye-opening moments was encountering Stephen Skronig as a teacher initially, and taking his class in American Political Intro to American Politics at the time, in which he was actually willing to talk about 19th century tariff policy. And in ways that I'm sure everyone else in the class found annoying, but that I found extraordinarily illuminating, that there's actually space to do things that I found interesting within American politics more generally, and that encouraged me then to be thinking more about how to do empirical stuff, and I find myself doing more and more of it over time. So of a certain type, obviously. So yeah, I remain hopeful that that there's space, I think, both for doing this specific kind of empirical, positive social science in the discipline, and that there's continued work to be done on this front. And I also think, though, I know you sort of want to set aside some of the normative stuff, but part of what I continue to find interesting about this, and part of what attracts me to it, is that there is a give and take between the normative stuff and the positive stuff, that they can speak to each other. They don't have to be sharply divided and sort of work on completely different tracks, but that they can, that there's possibility of doing empirical work that is fundamentally positivistic and what it's trying to do, tries to get the empirics right, is motivated by just trying to figure out what the truth is of that particular issue, but is inspired by, motivated by a set of normative concerns and questions as well, and speaks to, in some ways, a set of normative concerns as well. And that's a tricky balance to get right, but I hope that there's continues to be space in the discipline of trying to both be very serious about the empirics and take the need to be careful about the empirics very seriously, while also trying to engage big, important normative questions and speak to those questions in ways that people might find useful.
Emily?
Yeah, I had an additional thought about this studying constitutionalism as a positive social science exercise, which is that Keith and Mark and Sandy and Jack have also advanced that project by thinking about constitutions, plural. So state constitutions, but constitutions elsewhere in the world, comparative constitutionalism, and thinking about the US Constitution and our constitutional system as one of many. That is, I think, a sort of still very vibrant direction for doing positivist social science, to say, like, okay, well, we have got lots of constitutions. How do they work? How does this one work differently from that one? No one's mentioned that, but that is something else Keith, I think, has done, is to think about the technology of constitutionalism with reference not just to this single US Constitution, but to lots of constitutions out there.
Sandy.
Yeah, I think Keith is raising some very, very interesting issues about the sheer contingency where one goes. I went to Harvard. I have written that I probably had the happiest experience of any grad student at Harvard I've ever known, and that's because of Robert McCloskey. And I revered McCloskey, but he actually spent some of his energies in conversation being very suspicious of the behaviorists, like Walter Murphy. And as you know, one of the things that I think is wonderful about your book on the Supreme Court is, first of all, you've read all these cases. I have not. I don't think Robert McCloskey did. He focused on certain greatest hits and intuited certain understandings about the role of the U.S. Supreme Court and the American political system. But one of the really marvelous things about your book is that, from my perspective, you really demonstrated that his intuitions were basically correct. That is, that you can't understand the Supreme Court unless you place it in the overall American political system. Most of the time, whether or not you agree with Mark Tushnet that most of their decisions are noise, it is certainly the case that most of the time they're congruent with the general development. And then what really becomes interesting from McCloskey's perspective is those relatively rare occasions when they're one standard deviation away from the norm. And so the key question for us today is whether the U.S. Supreme Court is in that position and what the consequences will be. But it does seem to me, and this is in not the slightest way meant to take away from the real importance of your work, that one of the reasons I was certainly drawn to repugnant cases is that it did in some ways, as I say, reinforce McCloskey's or my intuitive understandings, but I was not prepared at Harvard to be anything resembling an empirical political scientist. If you had gone to Harvard, you probably would have ended up much more as a political theorist, because that's what the department was about. So, you can never underestimate the importance of contingency in one's life, including one's academic life.
And Mark.
Just first a shout out. You gave a nice shout out to Howard. We should probably both give a nice shout out to Roger Smith for his contributions to all of this. But in thinking about your comment question, so we have 90 members of a faculty in 3 buildings with 30 faculty offices. We have to divide them among them, and we call one building history, and we call one building law, and we call one building political science. And under one notion, I think I've tried to, as Keith do it, is it's an administrative convenience. You simply can't put all the faculty in one building. And it makes sense, to try and organize your offices so people have things to talk to each other. But you shouldn't think there's something called history, something called political science, something called law, such that the people in the history building have nothing to say to the people in the political science building, and everybody in the history building has something to say to everybody else there. And I think, a lot of us in this room, and again, I talk about the group project, of which Keith is a crucial member, have been trying to say the disciplines are administrative conveniences. They are not hardwired things that for many people in many spaces, you will be talking to sociologists, psychologists, and chemists. And not simply think just because your PhD has a discipline with them, you talk to everybody in that discipline. I think, by the way, here is a word of caution for Keith, having moved from a political science department to a law school. It actually turns out to be a bit more difficult to get into the communication with other disciplines, if for no other reason than when I was a political scientist, my students were taking economics, my students were taking history, inevitably. I ran into other people. Though in law school, maybe outside of Yale, where they're probably taking very little law and mostly in other departments, but in most law schools, that's all they're taking. And so the people you run into are other law people. But I think your question is important, and the way we design disciplines and reify them is important.
Yes.
Okay. So Keith, I wanted to see if I could get you to repeat something you tweeted a couple weeks ago. So when Sandy said, it's just bizarre to think of enforcing any kind of rule against rent seeking, and then he said, just think of what Florida has done. And I thought Sandy was going to talk about the ban on lab-grown meat. It's sometimes tough to tell on Twitter how serious you are, but Keith tweeted in response to that, I look forward to the court overturning Caroline products. So I'm curious, both, don't you think we should overrule Williamson v. Lee Optical? Somewhat relatedly, Mark says we shouldn't enforce a duty to protect against violence. I mean, shouldn't we overrule the Cheney versus Winnebago? I mean, aren't both of those very, very clearly wrong, such that they're prime candidates for overruling?
Sure. That seems fair. So for those who are not, so DeCheney versus Winnebago is a case on duty to protect, which the court ruled that the state, you couldn't sue the state for not doing a good enough job protecting you. The state was immune from such things under the 14th Amendment. And the Caroline Products case is part of a line of cases relating to how much the Supreme Court should intervene in evaluating whether it's in the general welfare or in the common good to have some economic regulations. And Caroline Products in particular was the New Deal move to say the court should stop doing those kind of things. Particularly nice in that context because that involved a long line of rent-seeking dairy industry legislation. So the rent-seeking beef industry regulation coming out of Florida is a particularly nice parallel that really ought to give rise to the court rethinking Caroline Products as well. But if they want to do it under Lee Optical, it wouldn't be nearly as nice of a parallel. But I'd be willing to do that too. So sure, I'm on board. It raises all kinds of questions that came up in the last panel, though, of course, about how to think about precedent and originalism and the like. But that's what law review articles would be written for. So. maybe I should turn my tweet into a law review article.
Interesting off the division of labor. I teach quite frequently in the night school at Maryland, and one advantage of teaching in the night school is you get a lot of people with degrees in other subjects who for various reasons need a law degree. And one year, the most strongest offense of DeShaney was from a student who previously had been one of the clear leftists in the class, and by the way, was later, I think, the top 1 or 2 student in the whole school. But she was a social worker. And what she argued, and interestingly so, very much a Posner kind of argument, saying, well, you could have this tort regime, but in fact, she said, based on her experience, the tort regime would lead to less protection. And one of the claims of originals, and I think it's part of Keith, is once you start debating whether a tort regime will lead to more or less protection, you're still discussing constitutional matters, but this is not something for a court. And so one might argue, again, once you discuss, you concede in some sense there might be a public interest to this, and you say to yourself, but, was the legislature truly interested in the public interest, or was it in fact interest group? You're again dealing with constitutional issues, but maybe not the constitutional issues a court can be concerned with. I'm not sure what the answer is, but I think Keith's scholarship helps us with ways of thinking about the different roles institutions might have in preserving the Constitution and the different modalities they might bring to constitutional analysis.
I'm a little surprised, given how much you emphasized in the last panel that we should only reverse clearly erroneous precedents, that we're going after Caroline products, because I didn't think that one was on the table. And I think that actually gets to a topic that was discussed in the last panel that relates to this one as well. How much should judges be doing? When I started off as a baby law student, I heard so many conservative lawyers and law professors saying the last thing you want is for the judiciary to intervene. We need judicial restraint. This was Justice Scalia. This was the original idea behind originalism. Let's stop having judges do something. And as I've gone through both as a lawyer at the Department of Justice and then as a law professor, the pendulum has swung, but it's just swung in a direction such that both progressives and conservatives want courts to be doing a whole bunch. The idea of standards of scrutiny, and of course Williamson versus the obstacle is about rational basis scrutiny, is both about empowering politicians to do stuff in areas the courts aren't going to touch, but also about judicial restraint. Because once we open this door, it's not just that the Supreme Court will get a few cases here and there about economic rights, but we have opened the floodgates for all lower courts to evaluate every single thing that states and localities do on a regular basis. I'm worried about that in a few areas of administrative law, but if we open up that door, then we are going to have very, very little left to the politicians.
I think part of the importance of Keith's move, certainly symbolic, and perhaps it will turn out to be an actuality, is that law schools are often relentlessly anti-empirical. We spend all of our time refining so-called theories of interpretation so we can yell at each other, and as we have this morning about originalism versus the others. But none of those need be rooted at all, unless you're a prudentialist. And then, of course, the role of prudentialism, it's Godzilla. It threatens to eat up all of these other modes. But actually, it would be really wonderful if law students had to take courses on data analysis or how to analyze the actual consequences of policy, what degree of confidence we can have when an argument is plausible. And I'm quite ambivalent about DeShaney because of the obvious fact that one can't expect the state
to pay an endless amount of money for any welfare good. You're always making trade-offs. And who should decide where those trade-offs are? And to what degree should one believe that William Brennan or anybody else has a genuinely evidence-based understanding of how much is enough, how much you might want to allocate to hospitals or other things. And, you know, right now, to put it mildly, I'm not impressed with legal education in terms of really focusing on these sorts of questions. And I hope you bring those and don't turn into another doctrinal lawyer.
I think that part's unlikely, but I just wanted to highlight a political development point that was in Tara's point about sort of what would happen if you actually overturned Caroline products in the current period, right? It would open the floodgates to litigation. One thing about the Lochner revisionism literature really emphasized was how much the courts generally just upheld legislation that was challenged under those kinds of doctrines that Caroline products put to bed. And one important and interesting question is, if you were simply to take Caroline products out of the picture and open those floodgates again, would the courts behave the same way now that we thought they behaved in the early 19th century, or as politics changed sufficiently, you get a different set of judicial outcomes, even if the legal regime looked like it was very similar. And of course, I should highlight the fact that Emily's positive rights book also emphasized the extent to which lots of state political actors were also affected by the fact that there was a question about how much courts would uphold that kind of legislation, but also how much legislation was deterred by the possibility courts might not. And so there is a sort of, as Mark Touchman would say, a judicial overhang there that affected the dynamics of how legislation got produced, even if the courts were not necessarily that active and willing to strike laws down, even under that kind of legal doctrine that would facilitate more striking down.
Can I add one other point to the judicial overhang, which I think is shown crucial in takings cases? If you wind up strengthening the Williamson versus Leopold test, what it will mean in practice is a great many claims that didn't survive summary judgment before will. And if we're talking about New York City, that's not a problem. New York City's got lawyers. If we're talking about the middle of nowhere, Mississippi, if the claim survives summary judgment, middle of nowhere may decide we can't afford to litigate if we've got a deep pockets plaintiff. And so it will have more effect than simply looking at a scorecard. And this is part of the Constitution outside of the courts. You know, it may turn out that sometimes if the progressives have deep pockets, the judicial rulings that say, well, you have to produce this advanced study, okay, you produce the advanced study. So whoever has, the more you go a mushy standard, the more deep pockets matter.
I think there's this haves come out ahead problem, but I also think there's more to the Lochner revisionism. I mean, so one side of it, I think, is very clearly, like, the courts weren't striking down all of this stuff. Legislatures got to make a lot of these choices left unmolested. But I think, I'm thinking of Howard Gilman's book here. His argument is the courts reached a point where they couldn't do it. They couldn't figure out a way to do it anymore that seemed legal or neutral or reasonable, which drove them to just get out of the business of doing it. So I don't think the only concern is courts will step in and overturn legislation. I think the concern is like, well, what standards could they use to do this, which is part of the reason they got out of the game. Yeah.
And just as one more addition on that, we also have a different judicial structure now than we did then. So starting in 1925, the Supreme Court got very large discretionary certiorari review. In 1988, it got virtually everything it hears is discretionary. And so the Supreme Court can't police the lower courts as it could have to a greater degree in the late 19th and early 20th century. So no matter what happens, you're likely to have a cacophony of different decisions among the lower courts and very little uniformity. And there is no capacity for a Supreme Court that's been hearing between 50 and 80 cases, even though it could hear more, in the last couple of decades. No capacity for it to resolve that. And I think the one thing we do know about our lower federal judiciary and our state court system is that they don't always agree.
That was a very good, coherent thread. So maybe it's a good time to stop and thank our panelists and thank Keith.